Thank you. So hello everybody, my name is Siofra Corr and as Nissan said, I am a second year PhD student at Queen's University Belfast. My research is focused on reparation processes for conflict-related sexual violence victims. The aim of this research is to illustrate how culture may be used as a lens through which to explore the complexities of recognising the cultural specificities that have been missing from more essentialist or universalist approaches to reparations in this context. So today I will be focusing on what a cultural lens may add to reparation processes. Firstly, I'll be discussing what are reparations, then what does the term culture mean, and ultimately discussing the importance of a cultural lens for reparation processes. What are reparations? What do we mean when we discuss them? When looking at reparations, especially from an international legal perspective, it would be remiss not to start with the Chorso factory case, which states that reparations must as far as possible wipe out all the consequences of the illegal act and re-establish the situation which would in all probability have existed if that act had not been committed. Now, whilst this is a good starting point, and it should be acknowledged that reparations have evolved in the past 90 or so years, this statement is still drawn on today. It asserts that reparations should undo harm from a very legalistic perspective, implying that reparations should act as a form of corrective justice. But today there are many other theories on the role of reparations in justice, including distributive, transformative, and transitional justice. Therefore, the Chorso factory case statement lacks in understanding the complexity of the society in which reparations may be awarded, but nonetheless it is a good starting point. So in following this international legal framing, my research explores reparation measures as those in line with the 2005 UN Basic Principles on the right to remedy and reparation, i.e. restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. These principles are the result of intense international negotiation and the work of Van Boven and Bassouni. Admittedly, these principles are rather broad in their delineation, but have still been extremely useful when considering the evolution and acceptance of reparations internationally. Yet they have left some gaps, as they fail to provide solid guidance as to how states should implement them in practice. Therefore, today, many recognise that the term reparations is more malleable than that provided in the Chorso factory case, as it can mean different things to different people in different contexts, especially in an international legal, visa local, social, and cultural context. My project explores reparations from a broad international legal perspective, but draws on more diverse theories when it comes to their design and implementation in transitional societies, and this is where culture comes in. So what do we mean when we use the term culture? Whilst analysing the literature from several disciplines, including legal, anthropological, psychological, and international relations, it is clear that the term culture is ambiguous. As noted by James Nafziger, the range of meanings is mind-boggling and the resulting confusion is rampant. Now, this may be due to the evolutionary nature of culture. As Yvonne Donders explained, culture is a process undergoing continual change with no well-defined boundaries due to multiple internal and external influences. Following the work of Akhil Gupta and James Ferguson, they observe that we live in a world of human differences, conceptualized as a diversity of separate societies, each with its own culture. Thus, in this globalized world, there are a multitude of identifiable cultures. But when we discuss identifiable cultures, they are not limited to national or even regional cultures, as separate societies and their identifiable cultures can range largely within the borders of a state. Thus, these differing cultures and perspectives are a key and relevant area of both international and domestic law in an increasingly connected world. Therefore, as the recognition of differing cultures grow, Further research is needed to understand how societies interpret law and culture on both the domestic and international levels. This is important when considering the current challenges posed when international organisations, such as NGOs and states, respond to cultural diversity in the design and implementation of reparations programmes. In light of this, my research follows the assertion that culture is not timeless, bounded and homogeneous. Therefore, it is important that the debate surrounding culture and law continues to better reflect the modern understanding of the position that culture is never static, and thus the law must evolve in its recognition of this. The cultural lens. When it is applied, it is important that we learn how to navigate or balance the local and international legal and cultural interests when designing and implementing reparations programs for conflict-related sexual violence victims. So where do we begin? Well, we need to first acknowledge the importance of cultural sensitivity and norms when it comes to conflict-related sexual violence, as this can be the first obstacle to reparations. An example of such can be found in Nepal, where conflict-related sexual violence victims have been completely neglected from any interim relief and reparations programs. Yet, when we talk of reparations, a lot of the literature refers to the approach being victim-centred. Yet this is an overly simplistic approach, as the entire society needs to be considered. Acknowledging the complexity of cultural norms in a transitional society is necessary, as this society has allowed or at times been complicit in the atrocities of others. Therefore, we must consider how do we include them in a cultural context-specific way forward, and allow the culture to evolve and allow for the recognition of the wrong suffered by conflict-related sexual violence victims, and provide them with the reparation programs needed. So I'm going to show you two examples. The first is of per cultural consideration when designing and implementing reparations, and the second shows that when culture is considered, it can result in more effective reparative measures. The first example is one from Guatemala. The state awarded compensation to victims of conflict-related sexual violence. And whilst this might sound good, the confidentiality of these victims was breached, as the checks they were awarded stated that they were victims of sexual violence. This created unnecessary exposure and stigma. So if we consider the cultural context some of these women lived, one of their only routes to economic security in the future is through marriage. And through their identification as a victim of sexual violence, they were no longer suitable. This process did not at all engage with the local societies from which these victims came, and resulted in the awarded reparations causing further trauma. Whilst I acknowledge this is a more extreme example, it did happen and shows the consequences of not acknowledging the cultural context in which reparations programs are implemented. But I don't want to be overly negative, so I'll end with my second example, which highlights good practice when considering cultural context-specific reparations. This is a picture from a report recently published by the Reparations, Responsibility and Victimhood in Transitional Societies project here at Queen's. It is of a memory hut for missing persons from Padar, Uganda, which is a community-led repertory initiative. This is a place where people who had their children kidnapped and never returned can remember them in their own way via their own rituals, and it brings the community together in recognising the harm. Whilst I acknowledge this isn't an example for reparations for conflict-related sexual violence, it is a good example that can be drawn on in the future. Therefore, when we design and implement reparations programs, we must look beyond the purely legal and what the state can do, and we have to engage further with the local cultural understandings of reparations and conflict-related sexual violence if we want to design and implement programs that are truly needed, wanted, and can be accepted without causing further trauma to conflict-related sexual violence victims and the societies they live in. So thank you very much for listening, and I really look forward to your feedback and any questions.